My name is David Myrland. We're going to look at a memorandum that I wrote. I'm not trying to change anything with the memorandum. I'm trying to explain the way I read the law. Then when I get the court to agree, then the court makes the changes. What I'm trying to point out is that the tax code is being misenforced in 3 very specific ways that are briefed in this memorandum. Now, you're going to hear me argue in the chapters that impose the taxes instead of the chapters that allow the IRS to take your money by lien or levy where everybody else works. I did my work in the chapters that impose the taxes because I began to read the code at the beginning. I didn't jump into the middle based on a bunch of other people's work. I understand the taxes, the way the taxes are imposed, the way they should be imposed, and the differences between the standard operating procedure of the IRS and the way the law says the taxes are to be imposed. I have the right to arrange my own affairs according to law. That means I don't have to guess about case law. I should be able to look at a statute and know that whether or not I owe a tax. If you sell your labor in America or make capital gains in America as a citizen of the United States, that's my first traverse. They tell me I'm that citizen, and I'm going to stay that citizen long enough to make an argument. I'm not going to argue that I'm not that citizen like everybody else argues. I'm not going to argue I'm non-resident alien. Sure, I'm a citizen of the United States. Great. Now they can have it their way if they can prove the tax code imposes a tax on the citizen of the United States. Any person born and naturalized subject to its jurisdiction. Okay? If all you do is make capital gains or sell your labor in America, they only use 4 chapters of the tax code to reach your compensation or your capital gains. Those are the 4 columns on this piece of paper. The 4 chapters that impose the taxes do not include Chapter 24, which is the W-4 form. Chapter 24 does not impose a rate of tax. Chapter 24 imposes the method of withholding, the W-4 form. So you could put in the 4th column to the right there, the last column in the bottom right-hand side, a footnote, Chapter 24 W-4 form. They use it on us, but it doesn't impose a rate of tax. This is about whether or not we owe a tax, not whether or not we're subject to the W-4 form. Okay, so I got 4 chapters that they use to impose taxes. On the far right, the far right-hand side column, at the top of the page, write Chapter 23, FUTA, Federal Unemployment Tax Act. That's an excise tax on employers. It's not an income tax. And your employer takes it right out of your paycheck. There's a window on your pay stub that shows how much you paid. One chapter to the left, Chapter 21, FICA, FICA, Federal Insurance Contributions Act. It's Social Security for employees. One chapter to the left. Now you're in the 2nd column on the page. Chapter 2, Social Security self-employed. And one chapter to the left, Chapter 1. Those are the 4 chapters that they use to reach you with capital gains taxes and tax on your compensation for services. It does not include estate and gift taxes. I don't do anything to do with those taxes. Nothing to do with them whatsoever. So now I have 4 taxes I want to argue my way out of because I want personal sovereignty away from the IRS. I want them to have no authority over me whatsoever. I know because I've read an abundance of case law, which sets me apart from almost everybody in the movement. I have this understanding of how to interpret statute because I've read hundreds of Supreme Court and U.S. Appellate Court cases which describe inside how you have to interpret statute, period. So when I interpret statute, I do it the way the Supreme Court says you must, and this is very strict. I'm going to look at very particular statutes, and I'm not going to look at more than 5 statutes. Definitions that I will look at are in these 4 chapters, but first I'm going to give you a couple of quotes from cases regarding how you must interpret statutory definitions. There's a very specific way you have to go about it. The Supreme Court is unequivocal in how you must approach a statutory definition, and I'm not going to paste a lot of these sites into the chat because we aren't going to key on this part of the memorandum, but as you scroll through the memorandum, look at basically paragraph 3.1. Look at paragraph 3.1. I'm going to teach you how to interpret statute. This is how you must do it. So you don't need a law degree to know that the Supreme Court said this is the way you have to do it. And as I scroll, I'm scrolling page 9, page 10, statutory definitions and the maxim of expressio unius est exclusio alterius. And here we learn about statutory definitions and how you must interpret them. Here we have under paragraph 3.9 the definition of the term define and the definition of the term definition. I'm scrolling. Look at the top of page 11. The top of page 11 gets right in to the thick of it. Top of page 10. Metropolitan was subject to Title VII, however, only if at the time of the alleged retaliation it met the statutory definition of employer. Magic. The next annotation. Thus, Congress did not reach every transaction. A person avoids liability if he does not meet the statutory definition of insider. The next paragraph. But we must adopt the plain meaning of the statute, however severe the consequences. I'm going to take these standards and we're going to look at some statutory definitions. I'm still on page 11. Let me see. In the middle there, the wording of the federal statute plainly places the incidence of a tax upon the, quote, producer, that is, by definition, upon federally licensed distributors of gasoline, such as the petitioner. The congressional purpose to lay the tax on the producer and only upon the producer could not be more plainly revealed. The statute has no provision making the vendee liable for this payment. We're on the memorandum. I'm on page 11. I'm reading one of the excerpts from the middle of the page, which was footnoted at 14, Gurley versus Roden. So we're in the memorandum. We're on page 11 of the memorandum, reading about statutory definitions and how you must treat them. I'm scrolling to page 12, top of the page. Second quote, it is axiomatic that the statutory definition of the term excludes unstated meanings of the term. As judges, it is our duty to construe legislation as it is written, not as it might be read by the layman or as it might be understood by someone who has not even read it. If the term political propaganda is construed consistently, then the challenges disappear. Okay. Scrolling further onto the next page, we'll cap this off. Look just above paragraph 3.12 on page 13. 3.12. Homes that do not meet the definition may not be licensed. Thanks. I think I've heard enough from the Supreme Court of the United States on how I have to look at a statutory definition. Now, I'm going to keep scrolling, and I see that if they can't explain the law, on page 14, if they can't explain the law, void for vagueness. You can't make me guess as to the meaning of the law. Footnote 26 is dynamite. And so I have this due process standard. They can't make me guess. So I'm going to challenge them using the language of the law. They can't deny that the tax isn't imposed by clear language. 3.15, there's, I don't know, 8 Supreme Court cases that say the tax has to be imposed by clear language. So I know I have this standard as a defense also. Paragraph 3.16 shows you a couple state constitutions that have the same standard built right into the Constitution regarding taxes. And at the bottom of page 16, as a wonderful, wonderful expression under paragraph 3.17, it is a fundamental tenet of due process that no one may be imperiled required at peril of life, liberty, or property to speculate as to the meaning of penal statutes. Amen. Page 17, Petitioner's Statutory Challenges, paragraph 4.1. This introduction, paragraph 4.1, 4.2, and 4.3, and 4.4, is adapted from the introduction that the Supreme Court wrote for their briefing in Brown and Williamson Tobacco Company versus FDA in the year 2000, or FDA versus Brown and Williamson. So this is how the Supreme Court says you have to approach a case. So paragraph 4.4, the starting point in every case involving construction of a statute is the language of the statute itself. That's what I'm going to do. And here's our first definition. On your chart that you drew on that blank piece of paper, this is the definition of citizen from Chapter 2. Does it include you or me if we are citizens of the United States, or does it exclude us from the definition of citizen? 1402 is called definitions. If they mention citizen, they're going to define citizen. An individual who is not a citizen of the United States, but who is somebody else, shall not be considered a non-resident alien individual. If they're not a non-resident alien, they're a resident citizen. This is the citizen for the purposes of this chapter. Then we have its implementing regulation. Scroll. Next definition, top of page 19, indented, section 3121. Write this down in your four-column chart. This is Chapter 21, FICA. An individual who's a citizen of the Commonwealth of Puerto Rico, but not otherwise a citizen of the U.S. I say that's not me. You're welcome to say that that's you if you're a citizen of the United States, but I say that's not me. I'm making my argument. This is my memorandum. And then there's the implementing regulation. The next indented statute, 42 U.S.C. 411b2, is the codification of the definition of citizen in Title II, Section 211 of the Social Security Act, and it expressly excludes me. An individual who is not a citizen of the United States, but who is this other guy, shall not be considered a non-resident alien, or he shall be considered the citizen. And then, for the heck of it, Chapter 24, I'm not subject to the W-4 form, but this definition of employee uses the term includes. So I have my Chapter 2 definition that excludes me. I have my Chapter 21 definition that excludes me. And since FUTA, Chapter 23 on the far right of your chart, is a tax on employers, I didn't include it in my memorandum, but scroll back up to the top of page 19, 3121E. That's the same definition of citizen that you find in Chapter 23. So in your fourth column over to the right, write 3306J, definition of citizen, same thing. I think I have just, under those Supreme Court cases about how I must apply and interpret a statutory definition, I think I've just proven that 3 chapters don't apply to me. And I make the argument. It's the argument I'm making right here in the memorandum. I say those 3 taxes don't apply to me. And here's my memorandum about it. You have a chart about it in front of you that I instructed you how very easily we can draw this chart out for a visual aid. And now we have the memorandum about it. I'm arguing that I'm not that citizen, but I left out Federal Unemployment Tax Act. They aren't going to take me to court for the Federal Unemployment Tax Act, and that's what the memorandum is written for, is me in court. So I think I've just proven I don't owe 3 chapters of the tax. That leaves Chapter 1 on the far left, doesn't it? The only chapter left that they reach us with. Section 1 is where we find the tax brackets, married individual, finally jointly, separately, head of household, surviving spouse, and single individual, and also capital gains in Section 1H. But look at your chart. We have 3 statutes that define citizen. And in Chapter 1, we have no statutory definition of citizen. They wrote a regulation that says citizens of the United States owe this tax. I'm scrolling in the memorandum and look at footnote 34. It's argued in paragraph 4.8 that I mention in regulation only 26 CFR 1.1-1 A, B, and C. It's in footnote 34. So before they wrote that regulation, write the regulation in the top of your left-hand column on your chart. Before they wrote that regulation, did they have a tax code that applied to Americans? No. However they define our citizenship. I don't care how they define it. Any person born and naturalized, sure, that's me. Long enough to tell you that's just a regulation. Oh, they hate that. They hate this argument. I've been taxed under a regulation this whole time. And they steamroll you on the definition of citizen in the other 3 chapters to double tax you, triple tax you. That's the nature of the scheme. They had a tax code that honored limited federal jurisdiction by those definitions of citizen and left us out of it. They wrote a regulation to drag it into the 50 states and taxed us with Social Security still that came out in 1935. That's the mechanism of the tax code. They defined your citizenship as what they thought it should be defined of, as any person born and naturalized. Sure, let's go for it, stupid. That's me. You struck the nail on the head there, Treasury Secretary, when you wrote the regulation. I'll be that citizen. Whatever. But it's just a regulation. The 16th Amendment says Congress can lay and collect this tax. It has to be a statute. Look at the top of page 20. There's the Constitution, 16th Amendment. Congress shall have the power to lay and collect income taxes. And then a quote from Commissioner versus Aker. But the section contains nothing to that effect, and therefore to uphold the Commissioner's addition to the tax would be to hold that it may be imposed by regulation, which, of course, the law does not permit. Excellent. So they had a tax code that didn't apply to us. It was perfect, written by bona fide geniuses to honor federal jurisdiction in every way, and then they wrote a regulation to make it apply to Americans, and then they steamroll you on the definition of citizen in those chapters. That's the first issue briefed. And you see at paragraph 4.9, I provide a summary. Here's what I'm telling you. Don't say I'm trying to say anything else. This is what I'm saying in my argument. And then I have questions presented for review under issue A. 5 questions that you have to answer if I'm wrong. These aren't questions asked out of ignorance. I ask questions about my conclusions. Now, that's your first argument. Here's issue B. Look at the bottom of page 21 of the memorandum. This is the second argument. I told you I was going to teach you 3 arguments, total of 5 statutes. I got 3 statutes on that chart right now, don't I? This is the 4th statute. 4 U.S.C. 72, public offices at the seat of government. All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere except as otherwise expressly provided by law. We just pretty much proved with the first issue why the Secretary of the Treasury wouldn't have the authority to leave D.C., didn't we? And so you follow the first argument with this argument as a 1-2 punch. They can't answer either of them. It's already been in a civil and criminal trial in the last 3 years. They can't talk to you about it. So I don't have a theory. This has gone into court, and they wilted. These 2 issues were in a briefing in U.S. District Court in August 2005. In Austin, U.S. District Court, and U.S. Attorney Stephen Bass asked for a protective order against the questions under Issue A and the questions under Issue B. I do this. This is not a theory. I've hit them with these arguments, and they can't speak to you. And here at paragraph 4.13, I point out that in the past they've pointed to 7621 as their authority to leave D.C., but it only speaks about the President of the United States. So I took that challenge away from them by putting it in my memorandum preemptively. And in Alaska, when this brief went in the criminal case, November 2008, look at paragraph 4.14, the statute cited underneath it. The DOJ said, the tax code applies to you. You're not a non-resident alien. 7701A9 includes the United States. The DOJ pointed at 7701 and said the states are included. Look at the note right above 4.15. Under this definition, Alaska and Hawaii were removed from applicability upon receiving their status as one of the 50 states. And the DOJ was stupid enough to point at this statute as a defense. That's how far off of the curve these arguments push the Department of Justice. And you see that on the top of page 23 under Issue B. Here's my summary. Here's what I'm claiming. Don't think I'm claiming anything else. Don't let anybody speak for me. This is what I'm claiming. And then I have questions presented for review under that issue. These are more questions that the DOJ needed a protective order against in August of 2005, 17 and a half years after they pissed me off. I'm between pages 17 and 35 of this memorandum as I instructed you, and I told you earlier in the call we would omit one of the arguments. Page 24 is the beginning of the argument we will omit. It, however, was the third issue in that brief that caused the protective order in Texas, but I don't argue this one. It's just about an OMB regulation, which is a slight regulation compared to a statutory claim. Now back to our 4-column chart that you have, a blank piece of paper in front of you with 4 columns, and then those are the 4 chapters that impose taxes in the code, chapters 1, 2, 21, and 23. In chapter 1, write down section 83. I'm the only one in the country teaching it. I briefed it first at the end of 1993, and by the October term of 98, had it to the Supreme Court 5 times. I wrote the book on Section 83. Oh, that's pretty arrogant to say. Well, that book on Section 83 was Exhibit A, 5 trips all the way to the Supreme Court, starting the U.S. Tax Court. Yes, I wrote the book on it. Arrogance is unfounded confidence. In fact, I wrote the book on it. Discovered it in late 92. I couldn't sleep, and I wrote a manual about its operation based on all the maxims and case law I discovered on it. Bottom of page 25, issue D. I've been deprived of section 83, 212, 1001, 11, and 12, or you couldn't tax my pay. We'll just say section 83 because we're not even going to get out of section 83 into these others. And I see here, paragraph 4.26. Section 83A explains how property received in exchange for services is taxed. It's the definition of income, folks. Footnote 37, 5th Circuit, 1992. Section 83 applies to all compensation paid for services. You see how the first 2 issues are jurisdictional outside of the tax code? Outside the tax code. This is one that says, oh, I'm in the tax code now because I got steamrolled or they proved me wrong. Well, now I'm inside the tax code. Here's a totally different argument. That's all. So it applies to all compensation. Footnote 38. Look at all. It starts with regulations and goes on through tax court cases and appellate cases. It applies to all compensation. All these cases say so, including tax court. And I'm the only one teaching it. A person that signed on to this criminal complaint to Congress, 80 members of Congress, January of 06. My co-complainant in the criminal complaint, one of my co-complainants, Tim Garrison, became an accountant with his own business in 1973. In 1973, he became an IRS enrolled agent, a private practitioner taking courses so many hours per year to remain qualified to represent taxpayers to the IRS. He's a co-complainant on my findings. He saw my findings. He researched every bit of it. He read the case law and said, I believe this is crime. I better file a criminal complaint with Dave against the Secretary of the Treasury and the Commissioner of IRS right away. When you doubt these findings, you're up against a 37-year accountant and IRS enrolled agent. You can't get a better endorsement in this country than that. So at the bottom of page, we're on the bottom of page 25. We're going to look at section 83 of the tax code. It doesn't say that the whole paycheck's gross income. It says if in connection with the performance of services, property is transferred, the excess of the value of that property over the amount paid shall be included in gross income. Oh, great. Now I got to figure out the amount paid before I know the excess to include in gross income. But it sounds like an amount paid is going to be excluded. What if I could get the value of my labor included in the value of any money, or in the value of the amount paid? Because I see the amount paid isn't gross income, just the excess over. What if the amount paid includes the value of any property that I paid for my paycheck? That would be great. It's a dream regulation, isn't it? If I had a definition of the amount paid that says, the amount paid is the value of any money or property. And we know that would include labor because labor is property. But I'm not a dreamer. Let's scroll. I see on the top of the next page under paragraph 4.28, Regulation 1.83-4B2 that says to figure your costs, you can use Section 1012 and the regulations thereunder. 4.29, Regulation 1.1012-1A, the cost of the property that you get is your cash or other property that you paid. I don't see them exclude labor. Where's your authority to exclude labor from cash or other property? Because here in 1012, the standard that 83 says I can use, it says cash or other property is my cost. How do you exclude labor from this? And they'll penalize you for asking. They don't have a law that provides they can exclude labor from cash or other property. Scroll. This gets pretty involved. We're going to skip it because it gets easier. Go to the next page, paragraph 4.33. Regulations under Section 83 require that 1012 be applied to figure the cost of petitioner's compensation. To figure one's cost or amount paid, one can also proceed to 1.83-3G, which says that the term amount paid in Section 83 refers to the value of any property. And here's the regulation. Amount paid. For the purposes of Section 83 and the regulations thereunder, the term amount paid refers to the value of any money or property paid. Where's your authority to exclude labor, the value of my labor, from the value of any money or property paid in this statute and regulation that explains how to tax my paycheck? They can't point to a law that allows them to exclude it. It's a policy. It's a policy. What I really like now is 4 Supreme Court cases that the government won, arguing that I'm right, that any means all of it unless you got a law that allows it. I'd really like 4 Supreme Court cases that the U.S. government won, arguing that you have to produce a law that says you can exclude it. And here we see in paragraph 4.34, 2 Supreme Court cases before my work in the 90s and 2 Supreme Court cases after my work in the 90s where the U.S. government won, arguing in the Supreme Court that the term any property means all of it unless you can show me where in the law the exclusion is provided for. That's damn handy. I didn't have these 4 Supreme Court cases in the 90s when I had litigated 5 trips to the Supreme Court. I didn't think I had to teach them how to read the term any, right? So I went cold up to the Supreme Court 5 times without these 4 Supreme Court cases. And I see on the top of page 28 from Monsanto. Monsanto was a heroin manufacturer and distributor who, under the Civil Forfeiture Act, when he was busted, they seized any property. They seized all of it. And he goes, hey, hold it. You got to leave me enough for attorney's fees. And they said, no, the statute says we can seize any property. And he argued all the way to the U.S. Supreme Court. I get attorney's fees, don't I? The Supreme Court said, no, I'm sorry, but all the heroin manufacturers fall into this trap. We're really sorry, but the statute says any, and you haven't proven that the law excludes fees for attorneys. That's an example where the government wins when it argues any property is all-inclusive. But if it loses, no, sorry, it's a policy that we skip around the term any. And that's what I've proven with these 4 Supreme Court cases. So I revived the argument, rebriefed it to include these lengthy excerpts you see through page 29 from Monsanto, the syllabus, and the Supreme Court is definitive, saying every circuit court that's reached this question has decided the same way. Any means all of it unless you point to a law. And then I get into other cases, other of the 4 cases, paragraph 4.37, lengthy quote from Gonzalez, page 31, page 32, there. So now I know when I read 1.83-3G, the value of any money or property, it includes labor unless they can provide a law that says labor is to be excluded. They exclude labor because you didn't buy your labor before you sold it. That's all. So everything you get when you sell it is a profit. But it's just a reasoning. It's a policy. It's a point of contention that they win because they're judges. But you see, I've gotten the argument honed down to precisely this point. There, now you know 3 arguments. And you see under the argument, I'm scrolling, I have the bottom of paragraph 33, there's kind of a graphic saying this versus that. You only have this on your side, and I got all this on my side over here in the argument. I scroll under Issue D, paragraph 4.47. This is what I'm telling you about the claim. I'm not telling you anything else. And then questions. If I'm wrong, you have to answer these questions, because you can't make me speculate as to the meaning of penal statutes. Now, just those three issues, and I have mopped up the IRS. They don't have a tax that applies to citizens of the United States till they wrote that regulation in Chapter 1, if that is my citizenship. And that explains why the Secretary of the Treasury doesn't have statutory authority to leave D.C. as required under 4 U.S.C. 72, doesn't it? And even if I was subject to the tax code, I got property rights amundo when Section 83 says the amount paid includes the value of my labor. Checkmate. 1, 2, 3. This briefing of the tax code. Now here's a totally separate argument. Think about whether or not the IRS could monkey with you if they could never assess you. If they had no assessment authority over you whatsoever, the tax would pretty much be voluntary, wouldn't it? If I owe a tax and I'm being levied, I must have volunteered into it, right? If they couldn't assess me. Because they got to assess you before they can come after you for it, don't they? Well, their assessment authority, I'm looking at page 36, paragraph 4.49. This is the source of their assessment authority, section 6201A. The Secretary is authorized and required to make the inquiries, determinations, and assessments of all taxes, parentheses, including interest, additions to the tax, assessable penalties, imposed by this title, which have not been duly paid by stamp. Stamp, you go to the index of the tax code, stamp, that's the 4300s and 4400s of the tax code, foreign insurers, and casinos. And this statute limits assessment authority to the taxes which have not been paid but should have been paid by law by stamp. That's what the word duly means, that the law requires they be paid by stamp. That's not me, but they assess me anyway. How do they get away with it? They can assess all this taxes, interest, additions, tax, and penalties imposed by this title which have not been duly paid by stamp. Such authority shall extend. Such authority, yeah, this real limited small authority shall extend to the taxes shown on the returns. And they say, oh, that's everybody. Everybody files returns. And they don't let you reflect on the prior statement, such authority. Such authority? Yeah, this real limited small authority to assess foreign insurers and casinos for the taxes they have not yet paid, but should have. That's the structure of their assessment authority in the current tax code, which is complex. Look at the 1939 tax code predecessor section, 3640. It doesn't have all that gobbledygook in the middle. In 1954, they made a concerted effort to expand the size and complexity of the tax code. So this second statute became the first statute when they amended it. Look how much more plain the 3640 is. Commissioner is authorized and required to make the inquiries, determinations, and assessments of all taxes and penalties imposed by this title or accruing under any former Internal Revenue law where such taxes have not been duly paid by stamp at the time and in the manner provided by law. That's the way it used to read. They just stuck a bunch of stuff in the middle of it to remove or to spread further apart the word stamp from the beginning. The Secretary is authorized. Now, is that a clever trick or is that really grade school? This is where all their assessment authority comes from, this statute. Now scroll. And you have under paragraph 4.50 a regulation that says we can assess all taxes. And it doesn't even mention the term stamp. This is a regulation written to implement that limited statute. They got their assessment authority through regulation. Otherwise, it would be voluntary because they couldn't even assess you if you didn't pay. This is where voluntary compliance comes from. It should be voluntary. It's not. They wrote a regulation. Can't have that, citizen breath. Okay? Now I see paragraph 4.53 under issue E. I'm going to summarize what the hell I'm saying under this argument. It gets real simple now, doesn't it? Statute restricts respondents' assessment authority to taxes duly paid by stamp, but which remain unpaid. Even 6201A's predecessor, 1939 Tax Code Section 3640, restricts respondents' assessment authority in the same way. I'm not unclear, am I? 4.54, Regulation 301.6201 deviates from statutory restrictions, that's called derogation, when it extends assessment authority to all taxes imposed by Internal Revenue Code. Had the respondent or the Secretary of the Treasury not written regulations deviating from statutory restrictions found in 6201, it could not assess any taxes other than those duly paid by stamp or having not been duly paid by stamp. This is petitioner's belief, and until it is dispelled with open discussion and logical application of law to the contrary, petitioner will continue to act upon it. Got a bad attitude in this one. Get the cuffs. And then I have questions under issue E. Wasn't that simple? Now you see why it's in the memorandum. I'm bringing arguments to them in magnitude. They lessen as we go further and further through the brief. The first couple, jurisdictional, it kills them. I'm not even in the tax code till you wrote that regulation, and you can't even leave D.C. Huge issues. The next one, okay, I'm in the tax code. How did Section 83 operate in your conclusion I owe a tax? So they get less and less as I go on. Now, issue F, am I within the scope of this criminal statute defining the term person in Chapter 75 on crimes? The term person includes, and so they enforce it on everybody. And all the appellate courts are square with that interpretation, but the Supreme Court in Meese versus Keene, 1987, looks at a statute that uses the term includes, and they construe it to be exclusive, that if it doesn't mention you, it doesn't include you. So the Supreme Court can go either way on this. But the appellate courts across the board see the term includes, and they say that means everybody. And I scroll to make the argument, and I know they don't like the argument. The way it goes, and then I have questions under issue F and a review under issue F. I'm going to make the argument that my liabilities don't arise from the fact that I'm a member or employee of a partnership or a member or employee of a corporation. That was the definition of a person in Chapter 75. And a good argument can be made under the void for vagueness doctrine that the average individual looking at that wouldn't know that the term includes changes the definition into an inclusion. I'm at issue G, paragraph 4.60 on page 40. Criminal liability does not attach where I've used expert opinion. And here you see I've briefed regulation and statute. If those aren't experts, I don't know what is. And so I make the argument that reliance upon statute and everything should relieve me from criminal liability. And I scroll 4.70, and here's a quote from U.S. versus Boyle, paragraph above paragraph 4.71, about how you can rely on experts. And I scroll through that argument. You can read that at your leisure later. Questions for review, and then due process in these claims. Issue H, paragraph 4.74 on page 46. What is willfulness? Here's a briefing of it from a DOJ brief in Hawaii. Am I willful? You have to hew to the law with indifference. Paragraph 4.75. Here's a regulation that says so. You can't demand more money than the law permits, or you can be fired, according to this statute. So I'm briefing due process rights, what they have to do to me and for me in any case where I have questions. Again, there's a quote from 4.78. There's a quote from Smith versus Guggen about the void for vagueness doctrine. I'm scrolling. Paragraph 4.79, Supreme Court case, when our government is the criminal, it invites anarchy. That everywhere, don't you? Paragraph 4.80, the IRS is required to know its governing regulations to apply them realistically, and this is the old mission statement from the IRS. It was too warm and cushy. They had to rephrase that one. And so I have questions under issue H, 4.82, my review. I want my due process rights. And then questions under issue H on page 51 and 52. Now, tax court's holdings. Very interesting. Scroll to the top of page 53. Here's the quote from Talmadge versus Commissioner, 1995 case, a 1996 decision, March 96, where they say because you didn't pay anything for your labor before you sold it, when you sold it, it's a profit. But they don't cite a law that allows them to exclude it. So when this issue was raised in the criminal case in Alaska in 2008 about pension payments, the DOJ did not cite Alaska because that guy had joined this complaint and this quote was already on record in this memorandum. So they couldn't quote or cite Talmadge, but it's the correct answer when you make the Section 83 challenge. Now that it's been briefed that any property means all of it, they know they can't rely on Talmadge even though it's directly on point. Talmadge is a case that I wrote in the early 90s and took all the way to the Supreme Court. He was one of the two that got docketed past the clerks to the justices. Then he got cancer on his neck and had to concentrate on the hospital instead of a Supreme Court case. That's how that one went away. But here's the tax court decision that was upheld by the Fourth Circuit, that you didn't buy your labor first, so everything you sold it for was a profit. Where's your authority to exclude the value of my labor from the value of any money or property paid, as we saw in that regulation? Talmadge was penalized $6,500 for saying in his November 1995 tax court hearing, quote, I will concede all facts of the case today if they'll just tell me how to comply with Section 83, end quote. So they can't point to a law that allows them to exclude labor, they just do it. So we're taxed under a policy. We go to prison under a policy. Sherry Jackson's in prison under a policy that the law does not support, even if you're in the statutes they say apply to you. Now, you have 5 statutes argued. You have 330, I'm going to your 4-column chart that we drew early in the call. Anybody that missed the early portion of the call, listen to this in the archive, and I'll take you through the steps. So have a blank piece of paper ready to listen to the call. On the far right-hand side, I got 3306J. To the left of it, I got 3121E. To the left of that, I got 1402B. Then I've got 4 USC 72. You can't leave Washington, D.C. There's 4 statutes. Then I've got Chapter 1, Section 83, challenge. I've got 5 statutes. That's all I've used tonight, and I've taught you 3 arguments. There's 20 people on the call, and you're still here. I don't have a single theory. This is easy, isn't it? How did Pete Hendrickson miss all this? Was a question I got asked in my call earlier today on No Confidence. My show is at 59615. How did Pete Hendrickson miss this? How did anybody miss it? If you start reading at the beginning of the code, you come to Section 83. Hold your laughter till the end. What's their excuse? Are they going to stand out there and call me a genius? Or are they going to admit that they're idiots, these people with curriculums? It's one or the other. I'm going to call them idiots until they call me a genius, because I'm not going to stand around calling myself a genius. That would invite all kinds of hell. But listen to what I just did to the tax code. 3 arguments, 5 statutes, checkmate. 4 Supreme Court cases saying I'm right through the 90s against the way they decided these issues. Scroll, page 54, above paragraph 5.4, you see them, tax court in Talmadge, 1995, try to dispose of the 6201A stamp tax argument. They do a terrible job. Petitioner also claims that Section 6201 Assessment Authority limits respondent authority to assess taxes to taxes paid by stamp. Section 6201 does grant respondent assessment authority and other authority with respect to taxes payable by stamp, but it also grants such authority with respect to all taxes. Wrong. Such authority extends to the following. Such authority, the limited assessment authority, extends to the following, as we saw in the statute. So I'm blowing holes in them right and left. And that's the function of the memorandum. Look in the middle of page 55, under paragraph 5.6. 1 year apart, these two tax court decisions. These are in here to keep the DOJ from citing tax court. Because in 1 year, 1983, the legal force requiring rejection of their arguments, apart from their assertions of personal political philosophy, which do not provide a basis for us, a court sitting to interpret the law, to decide the question dispositive of this case. And the next year, the pleadings do not raise a genuine issue of a material fact respecting respondents' determinations, but rather involve only issues at law. Therefore, respondent's motion for judgment on the pleadings will be granted. The final matter we consider is pleadings. So in the first year, he didn't bring us any issues at law, just political philosophy. Let's penalize him. The next year, he brought us issues at law. Let's penalize him. So I cite these two a year apart to show that since 1984, tax court's been on judicial holiday. Can we stick with federal appellate decisions and Supreme Court decisions, please? So they don't cite tax court cases against me generally. Now, top of page 56. Here's the heart of Social Security. In our tax code, I went through the tax code looking for references to the sections in the two Social Security chapters, chapters 2 and 21, looking for references to chapters 2 and 21, looking to references to the names of the two chapters, and went through the tax code. And look what I found, a reference to chapters 2 and 21. On top of paragraph 5.9, 26 U.S.C. 76515A. For the purposes of this section, the reference in Section 28A of the Revised Organic Act of the Virgin Islands to, quote, any tax specified in Section 3811 of the Internal Revenue Code, end quote, shall be deemed to refer to any tax imposed by Chapters 2 or 21. Chapters 2 and 21 is Social Security. And I just got a statute saying that Section 3811 of the Internal Revenue Code is the same as Chapters 2 and 21. So I went to Section 3811 of the Internal Revenue Code. It doesn't exist. But the Virgin Islands have been around a lot longer than the 1954 tax code, so I went back to the 1939 tax code, to Section 3811, collection of taxes in Puerto Rico and the Virgin Islands. A, Puerto Rico, B, Virgin Islands. In 1954, they split that statute up into Chapters 2 and 21, and that's why the definition of citizen remains in those chapters. Is that a sweet story or what? There is the statutory foundation or origin, the headwaters of Social Security, where the river was born. And they dragged it into the 50 states by stonewalling it, by crashing your currency in the 1930s. Have I got a deal for you, a new deal, a chicken in every pot? And we went for Social Security. When FDR knew damn well that definition of citizen was in Title II, Section 211 of the Social Security Act. Okay, here I am at the conclusion, 6.1. 6.2. Look at this, very important case law at the bottom of page 57. The first indented. There is sufficient evidence to support a conviction if, viewing the evidence in light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. Because this fact is a necessary element of the statutory definition of anabolic steroids, which is in turn a necessary element of the offense, failure to offer this evidence resulted in insufficient evidence to sustain the jury's verdict. This is what happens in tax cases. This was a drug case. That's Orduno Aguilera, 9th Circuit, 1999. Next case. No rational trier of fact could have found that this standard was met for Estrada. The record was barren of evidence that he participated in a conspiracy. Bold type, next paragraph. When there is an innocent explanation for a defendant's conduct as well as one that suggests the defendant was engaged in wrongdoing, the government must produce evidence that would allow a rational jury to conclude beyond a reasonable doubt that the latter explanation is the correct one. In Estrada's case, the government produced no such evidence. So you want to put an innocent explanation on the record, it shifts the burden of proof. So this is my conclusion, and then my verification on my memorandum. So I'm the only one swearing to it, whereas the RICO complaint the memorandum supports has 5 co-complainants all signing under penalties of perjury, of which I am one, and of which Tim Garrison is one, the 1973 IRS enrolled agent and accountant ever since. So there you have the memorandum. You can see the purpose it serves. Scroll back to the very beginning of it. The first 15 pages is a memorandum on how you have to interpret statute. You don't have a choice. The Supreme Court says when we seek to interpret statute, we do it a certain way. There's an introduction to me and my efforts here, the track record. Paragraph 1.2, here's where we've been. Paragraph 1.2 is about the protective order that was issued in Austin, Texas, so the attorneys wouldn't have to discuss the law for the government. And then we get to the paragraph 1.5, indented are several tax court docket numbers, my earliest cases, 1994, 1995. And then I get into paragraph 1.8, relied upon nothing but statute. Here are the major points. And then introduction to the memorandum. Here's the exhibits that comprise the 180 pages all told that went to 80 members of Congress.